Hi, Lee Phillips here. I want to talk to you a minute about marital rights. Your spouse has certain rights to the property. You have certain rights to the property too. They're called marital rights. You can't make out a will and cut your spouse out. Now, this is all state law. So states are all over the map as to what marital rights are, but generally every state has something that says a spouse has certain rights to the marital property. So marital property sometimes is defined as probatable property. And if I move the property into a living revocable trust, for example, it makes it so that it isn't included in what they call the elective share. If you try and cut your spouse out of your will, out of your estate, the spouse can always make take their elective share. And that ranges somewhere between about 30% of the estate up to maybe 60% of the estate, depending upon the state where you are. And this elective share is defined different ways in each state. Like I said, it could be the probatable assets. I can move assets out of the probatable category by moving them into a living revocable trust, for example. I can put my kid's name on as a joint tenant. That way it isn't probatable. It instantly goes to the kid when I die. I can name pay on death beneficiaries, transfer on death beneficiaries. All of this sort of stuff moves assets away from the probatable estate. Some states say that. States will often say probatable estate, but we can augment it. We'll augment it with anything that's in a living trust. We'll augment it with the insurance policies. We'll augment it with such and such. So, like I say, this is purely state law, and I'm speaking out of school here because I don't know which state you're living in. But you need to know that this thing called marital rights exists. And often you'll have just the husband's name or wife's name on a piece of property. And yet the title company will prepare a deed which has not only the owner's name, the husband or wife, but also the spouse's name. And we will ask the spouse to sign. Well, they don't own anything. Yeah, that's true, but they have marital rights to it. So we have them sign away their rights. And in fact, in many states, you can have the spouse waive their marital rights. Have them sign a document that says we waive marital rights. And in my trust, for example, that I write often, it has a provision in it which says the spouse is taken care of under the trust, and both spouses agree that they're going to waive their marital rights. So that sort of thing can be done. The marital rights are significant. The sheer fact that you're in the marriage carries with it some claim to the property that's accumulated during the marriage. And in some states, that claim, the percentage that the spouse gets in their elective share, the share they elect to take instead of whatever you gave them, or if you cut them out of the will, the estate, the elective share percentage goes up depending upon how long they've been married. So there are all of these different variations on it, but you need to know that there is such a thing called an elective share and marital rights when you're doing estate planning for a couple, or you're thinking about estate planning in your couple's life. Lee Phillips talking about the marital share. Oh, yeah, don't forget to love us and like us, and why don't you pick up our free ebook on how to use a living revocable trust?